Nation intercept asylum seekers at sea or send them back, or even send them to a foreign country for processing purposes. Global courts are issuing rulings on international border enforcement and the rights of refugees. Let me explain this. The International Foundation of Refugee Law is the 1951 Refugee Convention. Article 33 establishes what is called the principle of non-refoulement. This principle expressly forbids a nation from sending back an asylum seeker to a place or a territory where his life or freedom will be threatened. International courts treat this principle of non-refoulement as customary international law. It means that this principle binds all the countries on earth, including those who are signatories to the treaty. It means whether or not you sign the treaty, you must be bound by this principle. This creates a direct collision at international borders. First, the summary pushback at sea of land of migrants has been ruled by international courts as being illegal. Secondly, there usually is a strict legal requirement for when governments try to outsource asylum processing to third-party countries. Under international precedent, when a government decides to send migrants to third-party countries for processing purposes, that third-party country has to be declared safe, in that it will not reject the migrants nor send them back or to any other country where their life and freedom will be threatened. Even as countries struggle to tighten their borders, there is a general advocacy that the principle of non-refoulement should be the legal line. Advocates are calling that migrants or asylum seekers are not sent back or sent to third-party countries where their rights and freedom will not be protected. Does international law actually safeguard the rights of refugees? Or is this an impediment in the sovereignty of a country where a country decides who to let into its territory and who not to let into its territory? Make sure you like this post, share and comment. I want to hear your thoughts.